Good morning, everyone. Thank you for joining our webinar this morning. We will cover how the COVID-19 virus has impacted employees here in the United States on H1L1 and pending green card. And we'll take questions at the end. I have a lot of wonderful panelists here with me, 8 immigration lawyers practicing in various parts of the country. I'll introduce them and we will focus on immigration impact. And then we'll take a lot of questions. We've received a lot of questions already. We'll try to answer all of them. It's unprecedented times. This COVID-19, something we'll remember for the rest of our life. The government has actually done a lot and helping. Before we get into immigration, I'll just say a minute about what a wonderful government we have and a country we have that has the resources and the willingness to help. First of all, there's going to send checks of $1,200 per person to every single person every single adult in the US that made less than $75,000 last year. And the $1,200 will phase out till about 100,000 in income and then vanish thereafter. The federal government has announced that they will give $600 a week more than what the state gives for unemployment. And for the first time in US, independent contractors, gig workers, Uber drivers, and so on and so forth will get unemployment as well. Also, for almost the first time in US, the federal government is saying that please give sick leave to people who are sick, and we'll give you tax credits to make up for the extra financial burden on you. And a lot of benefits to small businesses. Over half of America works for small businesses. And if you have less than 500 employees, then the government is willing to give you through SBA loans because you've suffered economic injury because of COVID-19. And then probably the most beautiful thing the government has done, and that is SBA will give loans so that you can pay your employees as long as you don't reduce their hours and don't fire them. The loans given to you for a couple of months of making payroll shall be forgiven. A lot of our clients, all of you that have H1L1 employees, the work has reduced, but the expense has not. And if you work for a company that has less than 500 employees, then please make use of this payroll protection program loans through SBA. And finally, if you're at a company, mid-sized business between 500 to 10,000, then SBA will give loans. They're not forgivable, but they're very cheap interest rate loans. And also you will get payroll tax credits for not firing employees. So that in summary is what's in our 50-page document. We've prepared FAQs on the COVID-19. With that, let's jump into immigration. And my first question is to Dia Matthews. She's the managing partner of our Edison, New Jersey office. Dia, could you tell us what's going on with the H1 cap that just finished on April 1?
Yes. So the good news is that the H1B lottery was completed on schedule. The results were announced by March 31st, as was previously announced. There is the possibility of perhaps another round of selections happening before the end of the fiscal year. We'll have to wait and see. My colleague Li Hua Tan, I think, is going to be talking more about that. For the cap itself, the numbers, if for those who are interested, there were about 275,000 registration applications, which is a significant jump from the past couple of years, where they had typically been receiving about, I think, 190,000 applications. So this year it was 275,000. Interestingly, about 50% of all these applications were for folks with US master's degrees. And not surprisingly, 70% of the submitted registrations were for potential applicants from India. So that's the status as of now. We have 90 days within which to file the applications, and premium processing is suspended. Yeah.
Okay, thank you, Dia. Lee is our immigration attorney in our Santa Clara office. Lee, what has been the impact on 2021 CAP cases because of COVID-19?
First, COVID-19 didn't impact fiscal year 2021 H-1B CAP selection process. As Dia said, on March 27th, the USS announced that the annual limit for fiscal year 2021 H-1B CAP has been met and the lottery selection process has been completed. It also notified petitioners with the selected registration by March 31st, 2020. On the other side, the impact on petitioners' actual H-1B CAP filing is yet to see. If a registration is not selected and the status continues to show submitted, it will remain in consideration for selection until the end of the fiscal year, which is September 30th, 2021.
Okay. Dia, one more question for you. What is the USCIS plan for, we heard that they erroneously denied 100 H1s?
Yes, so we have anecdotal information that over 100 applications were denied erroneously. USCIS treated them as duplicates. So we don't know what triggered this. I think the consensus is that it was probably the same phone number which was used for two different registration accounts and things like that, which might have triggered the the duplicate denial. But again, as we all know, USCIS doesn't exactly have a reputation for being quick to respond to questions like this. So they've not issued a statement on what exactly they will do with these denials. And there was never an appeal process that was announced for this. So it's unlikely that anything will happen. But again, since there is the chance that they might go back into the pool and select some more cases, perhaps these, the erroneously denied cases will have priority when it happens. So we'll wait and watch.
Okay, wonderful. So Lee, back to you. What is the current process for filing of the H1 petitions?
Due to H-1B CAP selection and filing process changes this year, H-1B CAP subject petition must be properly filed within certain time period to the USCIS Service Center indicate on the relevant registration select notices. The notices we received have the following important information: a specific beneficiary confirmation number, the prospective petitioner's name, EIN, beneficiary's name, date of birth, passport number, as well as the USS Service Center for filing and the time period for filing, which is from April 1st, 2020 to June 30th, 2020. And accordingly, the USS updated the H-1B direct filing addresses on its website. As the online filing is not available for H-1B petition right now, petitioners will still need to file H-1B CAP subject petition by paper and must include a printed copy of the applicable registration selection notice in the petition.
Okay, thank you. So there is a lot of our clients are facing this issue, as many in the audience, that an employer is not able to pay an H1 employee because the work has shut down due to COVID-19 at a client location. So what is an employer supposed to do? So let's ask Min Kim. He is an immigration lawyer at our Edison, New Jersey office. Min?
Right. So, I mean, the requirement to pay, obviously, that goes to the obligations of the employer for the certified LCA. So, in general, it's useful to know that if an H-1B employer does not terminate the H-1B employee, and we define termination as notifying USCIS of the termination of employment by withdrawing the approved H-1B and offering reasonable expenses for return travel for the employee back home, then the obligation to pay the required LCA wage continues to exist. But obviously with COVID-19, that complicates matters. So we have to dig in a little deeper to certain obligations by H-1B employers for paying their employees. So we need to be clear on what the obligations are and who places the H-1B employee in something called quote unquote non-productive status. So we define non-productive status as any time during the validity of the LCA in the H-1B petition where an employee is unable to work. And the critical question we must all ask now is, what party imposed the non-productive status on the employee? Was it a result of the employee requesting permission to be in such non-productive status, such as the employee requesting for time off, a leave of absence, maternity leave, etc., or was the non-productive status imposed on the employee as a result of the employer's conduct or lack thereof, such as perhaps the employer not having any work available to give to the employee when the employee makes herself available to work, or the employer taking measures to furloughing its work staff, cutting hours, layoffs across the board. So I suppose just as a broader point, if the author of the non-productive status is the employee, the wage does not need to be paid. If the author is the employer, the wage does need to be paid. Now, kind of going, how this impacts with COVID-19 and everything that's going on currently, I acknowledge that obviously a lot of states, their governor's offices, and the governments are, ordering stay-at-home directives, and end-client companies are shutting down. So how does that affect this obligation to pay the required wage? I suppose the answer to this is a little less straightforward because, obviously the employer has no apparent control over deciding that the employee is in such non-productive status. If anything, that status was kind of imposed from an outside party to the employee. If a client project was available before, but the end client facility is now shut down, does the obligation to pay the employee still exist? Unfortunately, as it stands right now, the Labor Department has not issued any kind of clear guidance on this issue. So I suppose, we answer this question from a different vantage point. I suppose we can kind of derive at our answer by agreeing that the employee herself is not the one requesting, initiating, and starting the state of non-productive status. If anything, it was kind of imposed on the employee by another party. So therefore, conservatively speaking, and I believe the best practice rules for interpreting this guidance suggests that without any kind of intervention from the Labor Department to provide further clarity, we can conclude that the obligation to pay the required wage continues to exist for the employer in this scenario.
Okay, Min. So how can employers post the notice of LCA filing at third-party locations?
Right. So, I mean, we understand that, obviously third-party locations, client sites, a lot of them are shut down, and those folks are working from their respective residences and homes. So, the issue of posting at their end client sites does arise. Well, there are two ways that an H-1B employer can post at a respective, end client location, whether it be a physical wall posting or electronic posting. If the electronic notice obligation is done, instead, two criteria need to be followed. First, the H-1B petitioner must first inform the affected workers at the third-party site of the location of this electronic notice that's to be posted. And then secondly, the affected workers should be able to determine which electronic notice applies to their specific work site. So I can provide certain examples in achieving this. If the H-1B employer can post a link to the electronic notice for a particular third-party worksite on the end client's intranet or emailing the link to all effective employees at the third-party worksite, this would be an effective means.
Okay, thank you, Min. So Brittany Simmons is our immigration lawyer in Connecticut. Brittany, I have a question for you. So let's say our clients, some of them don't have projects for their employees. What are our clients' options? What can an employer do?
So one option to consider is whether there are any other positions or other projects, such as an in-house project or another end client project that the beneficiary could work at. And if they can do that, then I would go ahead and I would file an amendment. And what you could also do with this amendment is reduce the wage. Now, if you're going to reduce a wage with an amendment, you should consider if you're going to be moving them from say they're at wage level 3, if you're going to move them down to wage level 1, you'll need to assess the pros and cons of whether you want to do that, given that you could open yourself up to an RFE. Another option is if it's just a short-term situation where there's no project available and you can't make the wages, is to do a salary cut that's across the board. So that would be for all of your employees, not just your H1s. In the salary cut, you would need to have it in writing. You would need to notify all of the employees. You would also need to update the public access files for every affected worker. And with that, this kind of opens up another consideration where if you're going to reduce the wages of an employee, you have to notify them and give them, like they need to consent. So if they give verbal consent, that should be okay. But just to give yourself more agency, I would suggest having it in writing and amending the employment agreement and adding that employment agreement to the employee's file as well as to the public access file. Now, another option would be to make this file another amendment and have it be a part-time position. So if you're going to do a part-time position, I would also consider the fact that there is a potential public benefits issue, since H-1Bs now are under more scrutiny for this situation. Now, with COVID-19, there's several other public benefits issues that are not being considered with as high level of scrutiny. So in certain cases, it's not an issue, but if it's going to be something that's another different type of public benefit, then that's an issue that you need to consider. And another option is to lay off the worker. Now, if you lay off the worker, you need to arrange a way for them to get back to their home country. Now, obviously, there's a travel ban, so they have 60 days if they're laid off to make arrangements to return home. If this goes in any further past 60 days, then you can have them apply for a B visa, but they would still need to show their intention is to depart the United States. And lastly, the one that might be the best option at this point is to, if the business qualifies, is to do a Paycheck Protection Program loan. And that would cover the employee's wages for 2 months, and then you can reassess the situation after that.
Okay, great. So Brittany, if I'm an employer, can I cut the employee's salary or the hours?
So you can cut the employee's salary, but if you're going to cut the salary and it's if it's below the H-1B petition's offered wage, then that's going to run into an issue with a potential DOL audit down the line. So what you would need to do is, now these are unprecedented times, so your economic conditions make it so that you can do it for a temporary period of time, but it would have to be across the board. You would have to get it in writing, and you would still need to pay the beneficiary or the employee at the prevailing wage level. And
okay.
the same thing would apply for a reduction in work hours. So if you're going to go from 40 hours down to 35 hours, it would need to be across the board for all employees, and it would need to be in writing, and it would just be for a short period of time. So if it's for a few months while we're riding out this unprecedented situation, then that's okay. But if it's past that, then you need to file an amendment.
Okay, so you bring up an interesting point that one of the options is to lay off an H1 worker, but because of the ban, the employee cannot travel back to their home country. So let me ask you, Navdeep Miambar, she's a senior immigration attorney in our Santa Clara office. So Navdeep, can the employee stay in the US till the travel ban is lifted?
So Navneet, till date, there is no announcement that expressly assures that such affected foreign nationals are safe from violating their non-immigrant status and potentially accruing unlawful presence. I would say that absence of such announcement should not be assumed permission to remain in the US. So if you are an H-1B employee or employer, you should first check that if possible, that employee can work on another project, you know, if amendment may need to be filed, whatever needs to be done. But as a last resort, if we know that this person really cannot work because the end client location is shut down and they have to leave the US and cannot at this time because of the travel ban, they should look into filing change of status to B2 visitor visa by filing form I-539. This changing the status to B2 visitor will give you or your employee some time in the US to wait and see how USCIS responds to the COVID-19 situation for foreign nationals who are not terminated from their H-1B employment. So to sum up, you should take some action. Just don't sit if you are laid off or if you are like just waiting. Just take some action, talk to your employer, and try to change your status to B2 at the earliest possible.
Okay, thank you, Navdeep. So which brings up an interesting point. If we're going to cut employee salaries and make them part-time, and which requires, if the cutback is material, it requires an amended petition. So can we now file premium processing petitions, or has that changed with USCIS? So let me ask Jagan Tamarisa, our immigration lawyer in Reston, Virginia. Jagan, what is USCIS doing about premium processing right now?
Thank you, Mr. Chugh. The premium processing has been suspended for all types of I-129 petitions. Most popularly, HL is included in it, as well as for I-140 petitions and H-1B cap petitions. This is a very important development affecting petitioners, considering that petitioners paid nearly $545 million in premium processing fees during fiscal year 2019. Having said that, the agency did suspend premium before for transfers and amendments during 2018-2019. Now, if the premium processing has already been accepted before March 20, then it may be processed in 15 calendar days. If in the event it is not, the fees of the 1,440 filing fees will be refunded. So there is a possibility that the case that has already been accepted under premium may still not receive a premium treatment, and it is uncertain how long the suspension will last. But just because the premium is not available does not mean you should not submit your case. You should file it regular. If you are a petitioner facing an emergency and with the premium suspension in place, you can make an expedite request with your petitions, but you must demonstrate through documentary evidence that there will be a severe financial loss to the company or person, or urgent humanitarian reasons, or compelling government interest. But these are very tough standards. And under the current crisis, one can imagine how many expedite requests will come forward, making it difficult to separate genuine versus regular requests. So therefore, premium processing is going to affect the processing of all the petitions.
Okay, so if I can't do premium processing, what else can I do?
So an expedite request is one that can be placed, but again, there would be a demonstration of a severe loss to the company or person if that petition is not expeditedly processed. So that's one consideration that a petitioner should keep. But employers should also take proactive steps with the premium suspension in place. It is recommended that petitioners continue filing their applications on timely basis. Do not wait or hold filings for a premium announcement, even if you have ample time left on your petitions. And please do expect adjudication delays, especially for H4 and other applications that require completion of a biometrics appointment. A delay in filing may affect employment authorization for certain non-immigrants. Most probably, everybody should be aware that if an H1, L1, and certain other non-immigrants have timely filed their extension petitions, they can continue to work for 240 days beyond the I-94 expiration date. But under the current crisis, that 240 days also may prove to be insufficient. We don't know yet. Unless an exception is given for these categories, the employment stop after completion of 240 days. Therefore, thereafter, employees can remain in the US until a final decision is given on the application, but there is no need to terminate them, but just you take them off payroll. A delay in filing can cause uncertainty for those facing issues with maintenance of status, especially those who are in 60 days grace period and moving back to new employment, or those who fell out of status and are filing non-proton cases to get back into status. And of course, a delay in filing can affect ability to travel when the situation permits. Another side effect of a delay in filing could be for those applicants, especially dependents who tend to file L2 EAD or an H4 EAD along with the H or L petition. Presently, those who have EAD through I-485 filings and who have filed their extension permits can work up to 180 days beyond the EAD expiration date. But these benefits are not available for L2 and H4 EADs. If the EAD expires, you must stop work until the renewal arrives. Therefore, please be mindful of your petition I-94 or EAD expiration dates and file them as early as possible. As you can know, extensions can be filed within 180 days window. Back to you, Mr. Chugh.
Thank you, Jagan. Great answer. Let's go to Los Angeles to our immigration lawyer there, Analita Chavez. Analita, a question for you. One of the most asked questions in the last 2 weeks, can an H1, L1 employee file for unemployment benefits if they're laid off or their work is reduced? What's the answer?
Yeah, it's a great question. Well, because H1 and L1 employment is employer specific, generally, no, such employees are not eligible to apply for unemployment benefits because their employment is actually tied to the sponsoring employer. And this is because in most states, in order to qualify for unemployment benefits, a person must be free, willing, and able to seek any type of employment. An H1 or an L1 employee cannot claim unemployment benefits because they lack this freedom to work. But depending on state law, however, an H4 holder who has a valid work authorization is actually able to claim unemployment benefits if they have lost their jobs. But it requires them to meet certain requirements. So the H4 spouse has to have a valid EAD at the time. Their principal H1 beneficiary, so their spouse, must also be in valid H1B status. And on top of that, the EAD must also be valid throughout the period that the unemployment benefits are requested. So again, this just depends on state law because some states actually have specific prohibitions for non-immigrants to apply for unemployment benefits. So it's really recommended that individuals contact the Department of Labor in each of their states to find out if they're eligible. The other thing to keep in mind for unemployment benefits is that the Department of Homeland Security doesn't list unemployment benefit as a benefit under the new public charge rule, which makes inadmissible for green cards folks that have received federal benefits or aid. But lastly, I do want to remind people that Immigration is an ever-evolving area of law, and because of this, we don't know 100% for certain the potential future consequences of someone seeking and receiving unemployment benefits while on non-immigrant status. Back to you, Mr. Chugh.
Good, thank you, Annalita. Maybe some employee whose work is cut in half can give it a shot for filing for unemployment because they're still around in the United States. The jury is still out on if a part-time worker can apply. But I have another question for you. The $1,200 check, will non-immigrant workers get that?
Yes, that's good news that we have for that. So the stimulus package that you were talking about earlier in the introduction, the $1,200 check for individuals who are earning $75,000 or less per year, non-immigrant workers are actually included in that. So that's really great news for them. Also, other categories like TPS and DACA holders with valid employment authorizations may also benefit from this. So that's one piece of good news for non-immigrant workers.
Okay, great, Annalita. The not so good news is for the 10 million or so illegal aliens in the country, because they don't have a social security number, the government is not going to issue them the $1,200 check, including our spouses of H1 and L1 employees that don't have a social security number and have an ITIN number will not get the stimulus check. So Dia, I have one more question for you. What about green card processing? Should employers continue that? Can employees ask for their green cards to be processing to be continued?
Right. I'm glad you asked that, because I think everybody's so caught up in reacting to the current situation that people are not really thinking about consequences a few months later, right? So when it comes to the PERM, or the labor certification process, it has to manage there's two competing interests. There's an interest in bringing in a qualified foreign worker and protecting the rights of the US workers, right? And because of this, one of the requirements when somebody is sponsoring a PERM labor certification is an attestation from the employer that they've not laid off any people in that sector in the last 6 months. So for employers who have layoffs right now because of the business slowdown caused by the pandemic, they will likely not be able to file PERM applications for the next 6 months or so. But there's some ways that we can manage this. So what I would advise is that if you have a lot of PERM applications, if you're a company that sponsors a lot of cases, then have a discussion with your immigration attorney on how you can manage this.
Okay. Let's go to Gladys Gervasio, immigration lawyer in Los Angeles. Gladys, what is DOL up to? Are they going to give us a break?
Thanks, Navneet. So the DOL, Office of Foreign Labor Certification, remains fully operational during this time. And that includes the national processing centers, the PERM system, the flag system. So they do recognize that employers' operations are disrupted due to this COVID-19 pandemic. They did issue FAQs on March 20 to address employer concerns. So first, you can now submit a request for extension of time to respond to an audit or notice of deficiency, or to submit a recruitment report. Basically, all requests for information that has a deadline, OFLC will consider and grant an extension to respond. They further stated that if your deadline falls within March 13 through May 12, your response will be considered timely filed if received no later than May 12, 2020. Second, with respect to PERM recruitment activities, if you cannot complete your recruitment activities within the 180-day time frame, recruitment will still be accepted if completed within 60 days after the deadline. So this gives you sufficient time to complete the mandatory recruitment activities and file your PERM application. But please note that this extension applies only if you initiated your recruitment within 180 days preceding March 13. And that's the date when the president declared a national emergency. So this means that your recruitment must have started on or after September 15, 2019 to avail of that extension. Now, if you've already completed your recruitment steps during the 180-day time frame, you should still continue to file your PERM under existing regulations. And then third, for your PERM notices of filing, it can be posted within 60 days after the deadline, provided again that you initiated your recruitment within 180 days preceding March 13. Lastly, if you need to file an amendment petition because your employee is now working in a location that's not within the area of intended employment in the LCA and you used up the short-term placement provision, then your LCA posting will be considered as timely when placed as soon as practical and no later than 30 calendar days after your employee begins to work at the new worksite location. Back to you, Navneet.
So Gladys, the PERM notice filing requirement, most employees are working from home. So where am I supposed to post the notice? In my bedroom, family room, or kitchen?
It really is absurd, right? But for the LCA filing, we're just saying post them in your home office. So and then certify to the posting and then include that in the PAF. Now for the PERM notice of filing postings, we know that a hard copy notice of filing must be posted at the intended place of employment or your corporate headquarters for your roving employees. And in addition to the hard copy posting, you must provide notification in any and all in-house media, whether printed or electronic, that you normally use to recruit for similar positions. Now, what if your office is closed, you're unable to post the hard copy notice? Unlike LCAs, there is no electronic posting option under the DOL for the notice of filing. The conservative approach would be to wait until your office is reopened, and you have that 60-day extension if you started recruitment 180 days prior to March 13. But if waiting to reopen is not visible because your employee is running out of H-1B time, the best practice would be to proceed with the hard copy posting in your office, although it's an empty work site, so that you're complying with the black letter of the regulation. And on top of that, provide additional notice to your employees who are working from home by directly emailing them or posting them in your intranet, and this is to comply with the spirit of the regulatory requirements. So this is still a developing issue, and we will continue to monitor it.
Okay, thank you, Gladys. So is USCIS still working? Can you make appointments? What about medical exams and shelter-in-place rules? What is USCIS doing, Annalita?
Yeah, so also another great question. Just due to the COVID-19 and in order to safeguard the health and safety of USCIS workers, just as everyone else's, certain states are taking measures to institute shelter-in-place orders. USCIS has suspended since March face-to-face services with applicants at all offices, and this includes interviews, naturalization ceremonies. They have recently extended this suspension until May 3rd, and USCIS does expect to open again May 4th. However, as Gladys mentioned earlier, this is ever developing, and so we'll continue to monitor whether this will continue beyond May 4th. USCIS, though, has already started sending automatic notices to those impacted by the appointment dates, rescheduling them and setting new appointments and whatnot. So that is happening, thankfully. All the other services, all essential services, everything else in terms of case processing and all of that, those are still happening. It's just the face-to-face services, like biometrics, for example, that have been canceled by USCIS.
Okay, speaking of biometric, so Navdeep, are these appointments suspended for EA extensions applications?
So biometrics are suspended, but there is one exception here that even though it's suspended, they will consider biometrics for EAD applications for renewal. Means if you have filed an application for extension of EAD, then USCIS will reuse your previously submitted biometrics. So in order to meet this condition of reusing your previously submitted biometrics for an EAD application for extension only, you should have received a biometric notice from them, which has a date of after March 18th onwards. So if you were supposed to go to their office for biometrics on March 18th or later, and you cannot go because the offices are closed, USCIS will reuse your previously submitted biometrics. Just to clarify again, this is only for EAD extension, means employment extension applications. This does not apply to EADs which are fresh ones, first timers. Those will take time and the process will be slowed for those ones.
Okay, so Navdeep, while I have you on the phone, let me ask you, do you think USCIS will extend the 90-day period for filing H-1B CAP petitions?
We are hoping, but there is no surety till we hear from them. You know, they did not extend, going with the previous, they did not really extend the time period to register. You know, they ended it right on March 31st, and they did not give any extra time because of the current COVID situation. I won't be surprised if they do not extend the time beyond 90 days. So I would request all employers who are in the process of filing, if they were selected, please do not wait and do not expect that this can be extended. Right now we are working, we already have confirmation from our clients who got selected, and we are already filing LCAs. So we are getting the process started and want to complete this as soon as possible.
Okay, great, thank you. So Sasha, we're done with our presentation and we'll do the Q&A now. See if the audience can ask questions or send in questions, and we'll take questions. So the first question, let me ask this to Min in our New Jersey office. Min, here's a question. Can a F1 OPT worker stay in the US as long as their status on their H-1 petition shows as submitted?
Right. So, I mean, when it comes to the H-1B CAP registration that everyone on the webinar, the audience is familiar with, you know, USCIS, you know, did provide that 3 results will be, you know, will be the potential outcome for every registration application. It's either selected, submitted, or for all purposes denied and rejected. Denied and rejected is only reserved for if USCIS, whether it be they made the correct you know, analysis, or as my colleague Dia mentioned, you know, if there was an error and it was erroneously denied, but the basis for the denial and the rejection is that USCIS believed that there's a duplicate registration improperly filed by the H-1B employer. So kind of removing that, that leaves 2, selected and submitted. For all intents and purposes, I suppose this is a new platform that USCIS is rolling out, so we, you know, we can't say for certain, but selected, you know, means that it was not selected in, I mean, I'm sorry, submitted means that it was not selected in the lottery. We don't know if USCIS is gonna hold some kind of wait list and reserve and do another selection at later on. But I suppose given the sheer volume of registration submitted, you know, in excess of 270,000, I suppose, you know, we can be of the conclusion that it was not selected in the lottery, and therefore an F1 student, if they are close to expiring under EAD, they would have to make arrangements to, you know, either depart the country or look for some other visa category, such as a B1, B2, or extending their F1 stay and continuing the university.
Okay, wonderful. Sasha, do we have a question from our audience?
Someone had raised their hand. Please click raise your hand again, and then we will enable you to talk so that you can ask your question verbally.
Okay. In the meanwhile,
Hey, hi, my name is Goodly and I have a question. So my husband is an H1B employee, but right now I'm on an F1, but I have an SSN. So are we eligible if I joined under the stimulus package, if our income is less than 150,000 USD for both 2018 and 19?
yes, you are. Every single person who has a social security number and is a resident alien for tax purposes, not illegal. Resident alien in the tax code is defined as someone who is a citizen or a green card holder or has spent over 183 days in the US and has a social security number and the income is less than $100,000. Then the spouse, the same way, if the spouse has a social security number, they will get the stimulus check at $1,200 each and $500 per child. The child also needs to have a social security number. Okay, any other questions? Or I have many. If somebody raises their hand, we'll ask you. In the meanwhile, Navdeep, since you talked about biometrics, the question is for EAD extension filings, would the biometric fee will still be required?
As of now, I would recommend to submit the biometrics fee so that your application does not get kicked. You know, when you file application, it goes to the control room, and they have like a check mark, and they really go along with that. If something is missing, I would be surprised that they send your packet back and do not accept it, and that can delay the whole process further. So please keep submitting your application with proper fee. And if they do not need it, they will send you back. But most likely looks they will keep it, and they will, you know, they can call you for biometrics later because now it's going to delay the process anyways. But please do submit the whole fee.
Okay. A question for you, Gladys. Someone's working from home and the LCA lists the client site, which is far away. What are they supposed to do with the LCA posting while they're working at home?
Oh, so Navneet, if the H-1B employee's home address is in the same area of intended employment as the work site, you don't need to file an amendment or a new LCA, just need to post that LCA at his home for 10 days. So an area of intended employment is an area within normal commuting distance is the place of employment where the H-1B employee is employed. If the place of employment is within the same metropolitan statistical area, any place within that MSA is deemed to be within normal commuting distance, but it doesn't always have to be within the same MSA as long as it's within normal commuting distance. Now the DOL hasn't specifically define that, but based on our experience, they would say we can consider like 50 miles, 60 miles as within normal commuting distance. Now, if the employee's home address is outside the area of intended employment and you've reached the 30-day work limitation on working from home under the short-term placement option, then you have to file a new LCA and an amendment petition for that.
Okay. Dia, question for you. Somebody's asked a question that they've reduced hours at one of their companies from 40 to 30 hours for H1 workers, but they have another company. Do they have to mirror the same cut at the other company, or they don't have to do anything at the other company?
So the question, if I understood correctly, is whether they are bound to implement the same reduction in hours in a related entity?
Yes.
Is that the question? No, it's, the reduction in hours is governed by business reasons. There is really no immigration guidance on that. So you can make a different decision when it comes to different entities.
Right. Okay, great. Any other questions in the audience? Okay. Anything else you guys want to cover that somebody said something and it reminded you that, hey, this should be said as well? Anything else anyone wants to cover?
So, Mr. Chugh, we have questions in the chat window. I don't think we got all of them. Do we want to take that next?
Sure. If you have a question you want to answer from the chat window, please go ahead, whoever.
All right, so this is an interesting question from, okay, so the question is, will applying for an SBA loan or a payment of, or a paycheck protection loan cause any problems for H-1B employers when it comes to H-1B applications or green card applications later on? I guess the question is, will it prejudice their ability to pay the H-1B or the green card wage later on? I think it's a good question. I don't think it would have an impact. Because the criteria that we, for H-1B applications, first of all, there is no requirement as to ability to pay the wage. USCIS looks at the overall, the factors that they look at are employment relationship, a valid employment relationship and things like that. So ability to pay doesn't feature there. When it comes to green card applications, yes, the ability to pay the wage does matter, but it's a different criteria that is used for that. So the fact that you've availed of a loan, a bank loan, will not prejudice the green card application. And I would think that the same will hold good for an SB or a PPP plan.
Okay. So another question we have is, will the payroll protection program cover H1 and L1 salaries? The answer is yes. SBA has come up with several loan provisions. The most beautiful one is the payroll protection program. And basically, SBA and through the SBA CARES, through the Senate CARES Act, has set aside several $100 billion to lend to employers in the US. Please don't cut employees' hours. Please don't fire them, because when employers fire their employees, then they lose their health coverage as well. And in this time of dire need, we don't want more people without health coverage in the country. So the government is saying that please keep your employees. We will pay their payroll for 2 months, for 8 weeks. And the government is willing to cover the payroll, the state taxes on the payroll, medical insurance, dental insurance, and retirement benefits. So the SBA payroll protection program loan application asks for what is your payroll for 8 weeks. We will give you a loan for 2.5 times that. What is your payroll for 1 month? And we'll give you 2.5 times that. And the extra half to make up for the insurance and tax and retirement benefits. And after the loan is funded, by June 30th, the government will want to see that you didn't lay off anyone. And that includes H1 workers, L1 workers, green card holders, any other visa category workers, and of course, citizens. And the government will forgive the loan. SBA will forgive the loan. So there is no discrimination being made. The SBA and the government doesn't want any worker fired of any status. So, one of the best, we're hoping that the entire world is hoping, or at least all of us in the US are hoping, that this does not last more than a few weeks. And that's why the SBA loan is for 8 weeks. And through this hardest time, if you can get some help from the government, then the loan shall be forgiven. And the loan will only cover employees that make less than $100,000 a year. And if somebody makes 120, then only 100 will be covered. The balance 20 is on you. And yes, so the answer, short answer to the question, are H1L1 workers' salaries be covered under the payroll protection program? And the answer is yes.
Here's another question. The next question is for H1 extensions, when the beneficiary has maxed out the 240 days, right? So the 240 days here is the time that you're allowed to work while the case is pending adjudication. So what happens to extensions which have gone beyond the 240 days? Anybody want to take this question? Okay, so I think the short answer is unfortunately there's no automatic extension. This is one of the concerns with the current situation, that CIS has not really addressed, has not provided for an automatic extension. Many other countries have actually given automatic extensions for visas and things like that for 60 days. Here in the US, they have failed to act on it. So if the person has maxed out the 240 days, or has maxed out the 6 years of H-1B time and has not yet secured the I-140 approval, they're out of luck. They will have to either depart the US or, I guess, wait around. Just want to add here that we received notice this morning that the American Immigration Lawyers Association has actually sued CIS for failure to act and for failure to respond to these critical questions.
Okay, wonderful. We have a couple of minutes left for any other questions. So I have a question. If on non-productive status due to H-1B using sick leave, is the employer required to ensure that the benefits received are up to the LCA wage by paying any difference? So I suppose the question is that somebody is sick and they filed for sick leave, and the benefits they're receiving is not enough up to the LCA wage or the petition wage. So one of the answers to this question is that this person should guide their employer that if somebody is on sick leave and the business has less than 500 employees, and if the employer pays the LCA wage, they will get a payroll tax credit on their payroll tax return, so they can pay the full wage. The government is actually mandating for companies under 500 employees that you have to give 80 weeks of sick leave, which is 2 weeks, and the government will give payroll tax credit. So maybe it's just an education to the employer. Okay, that does it, folks. Thank you so much for joining, and thank you, my fellow panelists, all 8 of you. Great job educating all of us. And as soon as you hang up, you will hear the most shocking news that US is under lockdown. Just happened a few minutes ago, so we have another life to start planning for as soon as we hang up. All the best, everyone. This too shall pass. We shall be fine one day. Don't worry too much. All right. God bless.
Thank you.